You know, it has been said that men can write perfect ethical systems, but nevertheless, they cannot stand being watched when they go out at night. And I think that, to a large extent, is the situation with the DDC. The DDC is a departmental disciplinary committee for which I used to work. I was a former principal attorney there for 6.5 years. I alleged that upon learning of the DDC's pattern and practice of whitewashing and routinely dismissing complaints leveled against certain select attorneys to the detriment of the public that the DDC is duty-bound to serve, I reported this wrongdoing pursuant to my rights under the First Amendment to the United States Constitution, and importantly, my own ethical obligations under the New York State Code of Professional Responsibility. In response, however, rather than attempting to address and rectify the problem, my supervisors embarked upon a campaign of abuse and harassment of myself, including a physical assault on myself by the first deputy, Sherry Cohen. I conducted an intensive investigation of a case. My caseload supervisor, Judith Stein, approved it, and so did Thomas Cahill, who was then the chief counsel. It was recommended for charges, and then suddenly it was dismissed. The complainant called me, he happened to be an attorney, and asked me how could something like this happen. I requisitioned the file and found that it had been completely gutted. What had been a file which was almost 3 inches thick was suddenly 1 inch perhaps. All of my work product was taken out. Verizon phone records that I had subpoenaed were not there.
And this was an actual case you worked on?
Yes, sir. Yes, Senator.
And the documents were missing?
The documents were missing. Yes, the documents were missing. Another such case, which I recommend and I refer to as whitewashing, was a case which was intensively, again, investigated.
When you say intensively investigated, what do you mean by that?
Okay, I will bring in the complainant, maybe once, twice. I'll bring in witnesses. I will have a deposition. I will subpoena documents. I left no stone unturned. I had a reputation as being thorough and conscientious. In that case, it was recommended for an admonition because we could not really prove conversion. In fact, this was a case that many of my colleagues, at least 4 of my colleagues, and I agreed, that there probably had been conversion, but we couldn't prove it. And so we had to just settle for an admonition. Instead, Sherry Cohen came into my office holding the admonition in her hand and saying, "This is too harsh. I can't let it go to the policy committee because they may send it back for charges, and I can't tie up an attorney on a trial for 6 months." And I replied, "That happens all the time." And she said, "No, I am going to rewrite this." And I said, "You cannot ethically and legally rewrite something to achieve a desired outcome. You cannot skew something to achieve that outcome." Nevertheless, she said,
Was
6 months.
Was this just in this one incident, or you discovered a pattern?
I discovered a pattern, and this is the second example I'm giving you. Okay. In any event, she took 9 months to rewrite it, and it went by under the radar, and that is what I mean when I say cases are whitewashed. For example, another case that I had, it was agreed by my caseload supervisor and by Cahill that there were 3 elements. And one of the elements was misrepresentation to us, which is very serious. Sherry Cohen looked at me very earnestly and said, Christine, you know what happens if they lie to us. They can go for charges. I don't see misrepresentation here. I only see failure to pay a lien. So she took the case from me and took out the misrepresentation, and he got an admonition purely for failing to pay a medical lien. That is another example. In any event, I think that you have a good idea of how from the prior gentleman. However, I have a recommendation, and my one recommendation that I would like to make, however, is on the last page, which is, I think that the policy committee should be disbanded for the simple reason that it is rife with conflict. As the gentleman before said, he is with a large law firm, and that they serve without pay. It is not coincidental that on one occasion at least, when one of their partner's brother got into trouble, that it was taken away from me and handled very quickly and expedited to their satisfaction. I think that the policy committee is actually in violation of Judiciary Law 90.10 because they are not...
Ladies and gentlemen, we can't, please hold the applause. We're trying to...
May I ask you a question, please? Just want to be, just so I'm clear, because A, you're saying that there's preferential treatment in this decision making, in this process, that there are those who, because of their stature or their connections, are not prosecuted or investigated or whatever the appropriate terminology is.
Or handled lightly.
Or handled lightly.
Yes.
That's, just want to be clear that that's what you're saying.
Yes.
Number two, if I may. Number two, you also say that you were employed at the DDC and you were subjected to various acts of discrimination and harassment as a result of your race. So now, are you saying that there's a racial or a view at some of these cases as well, or are you just saying that as it relates to just your own particular relationship at the agency? My allegation is that there was a pattern and remains a pattern of discrimination against minorities at the DDC. Okay. For many...
Ladies and gentlemen, please, we don't need
for many
any
years,
applause.
for example, there was not one minority supervisor, although several of them were competent. Let me just finish the point, however, if you don't mind. If you are not an employee of the court, you have no right under 90.10 to know confidential information, which was just testified to. And these members of the policy committee are not employees of the court. They're not employed by the court. They're outsiders, and they have no part to play because it's a direct violation of 90.10.